Well, hello. I was gonna say good morning, but it's just morning to me. I'm sure you guys have all been awake for a while. That was really fun. I tell you, I have the most fun making my thumbnails. Melissa says, "Is there anyone more tiresome than this woman and her team of legal beagles?" And the answer is no. It's no. It's just no. No. This is basically a PSA to the world to say that after extending discovery by how long, all the deadlines got changed. After serving a Costco bulk subpoena printed on, what did Bruce call it? A mimeograph? We talked about time travel, that she had to have time traveled to print out that ridiculous subpoena. But she subpoenaed 107 of us. In addition, to the other subpoenas that she served on specific people. She still has nothing. And it makes me really worried for poor Andy from Popcorn Planet because he's her last chance. So you know she's going to fight so hard for something. But first, let's talk about the seriousness of this accusation. Also, the difficulty in proving this sort of thing, because this isn't like an automatic granting of a wish. As much as she would like it to be, you don't just get to say, "Hey, judge, these guys did this. It's really bad. Can you punish them with that?" It has to be proven. And like everything else, there are standards that must be met. However, like everything else, it falls to the court. The court means Judge Lyman. And we're going to see again in this episode, in black and white, why that's a problem. With this motion came a pileup of documents. Even Stephanie Jones got in on it. She had the nerve. After everything she's done, she had the nerve to jump in and submit it. And so that tells us something, that they're still a team. And I just can't wait for that thing to go south. Now let's talk about the rule that we're going to consider today, and it's 37E. It was amended on December 1st, 2015. And so prior to that, we had what's called a circuit split on a question about the previous law, whether negligence in the destruction of relevant evidence was sufficient in at least some circumstances to support the instruction of an adverse inference. And we're going to get to adverse inference in just a moment. It's something that Blake has asked for. But first, I want to say, keep in mind that circuit splits are not ideal because they can lead to forum shopping. So if there's another circuit that serves your case better, people may attempt to try to somehow finagle to get in under that law. And we've seen Blake do that here. She wants some things in California, some things in New York, and she has very specific reasons for those, as we've started to see. Hey, Christina. Now, I realized I talk about circuit a lot, and maybe you don't all know what that means. Let's go back to this chart, and if you guys haven't seen my last video, I introduced this chart. We're just talking about the left side of it, the federal branch, because this case is in federal court. And if you're wondering where Judge Lyman is on this chart, he's the very bottom left. Federal district courts. He is in the lowest court in the federal branch. Now, if we look right above it in green, and I've put this beautiful pink arrow, it's about the U.S. Court of Appeals. Now, when we talked about this before, and if you missed that episode, when the Court of Appeals rules on a case, their decision becomes what's called binding authority. That means that the court below, the federal district court, the court that Judge Lyman is ruling over, when they have a situation that involves that rule, that binding authority, they have to follow it. They don't get to say, "Well, I don't really agree with that decision. I don't like that decision." They have to rule according to that higher court's decision. That's why it's called binding authority. because they must. Now, we've already seen one instance in that video where there was a clear binding authority, both from the Court of Appeals and the U.S. Supreme Court, and additionally, the actual federal statutes, which are the laws. And yet he said, well, here in the Southern District of New York, we rule this way. And that's a huge no-no for a judge. They're simply not allowed to do that. Now, if the U.S. Supreme Court has a ruling, everything below them, the U.S. Court of Appeals and the Federal District Court, they are bound by that ruling. So each circuit has their own Court of Appeals, and it's binding within that circuit. So if we look back at this circuit map, so each one of these, as you see, 1 to 11, have their own U.S. Court of Appeals. So within their circuit, as you see, it involves multiple states. Every federal court, district court in that state must abide by that binding authority. Now, for example, what happens in the Ninth Circuit doesn't automatically transfer to the others. That's called persuasive authority. So a judge in, I don't know, Circuit 10 can look at what they ruled in 9 or 8, and it can persuade him, but it doesn't bind him. So that's what we mean when we talk about the circuit rulings and the circuit splits and what the circuits are all about. So what we had in this case is the First, the Second, the Sixth, the Ninth, and the DC Circuit. They had binding authority that, one, said that negligence could be sufficient for an instruction for this adverse inference. The rest of the circuits, in gray, they required a higher showing of culpability. They had to show bad faith. That's a higher standard. They had to show willfulness. They had to show intent to deprive. And these things, they sound like they're not a big deal in regular, when we use those expressions in day-to-day speech. But when you're looking at them from a legal standpoint, all of those things do have higher standards to prove. Then underneath that, we have both of them. So this is all of them. Required a showing of prejudice before an adverse inference instruction could issue as a sanction for loss of evidence. So let's talk about adverse inference. We know that's what she's asking for. What does it mean? This is a legal conclusion that's drawn against a party when they do not provide evidence that's expected or requested. So we're going to see a situation where a woman based her entire lawsuit on a report that she supposedly had. It turned out she had never actually had it. She had seen it, she says, a few years ago. So in her case, it was expected that she was going to bring that evidence. In other cases, it's requested, like through a subpoena. If under those situations, a party doesn't bring that evidence, this inference suggests that the missing evidence would have been unfavorable. So they're asked to bring forth evidence, and they're like, well, I'm not bringing that. It's going to make me look guilty. And so they destroy it. When you don't provide that evidence, this is a possibility that the jury can be told they got rid of that. They didn't bring that evidence, and it's possible, and you can view it as that evidence was going to be unfavorable to them. So that's what she's claiming that they've done in this situation. But not every situation of a failure to bring evidence automatically assumes this. So that's kind of what we're going to talk about today. These rules, does this happen every time? Is it the case in this case? Is what she's asking in harmony with this rule. So in December of 2015, that's when this new rule was written. And it's very, very clear. and I love it. Oh, bushbirds are here. See, I'm not supposed to be peeking, but you guys get a mention in this episode, by the way. So here's the law E: failure to preserve electronically stored information. And this is the ESI that you're going to see throughout all of this. ESI, that's what it means, electronically stored information. So that should have been preserved in the anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery. This is what the court can do. Here's a two-pronged standard right here, and we're going to see this come to life in binding authority in a moment. But this is what the actual statute says. Here's the two prongs. Upon finding prejudice. So prejudice is never just assumed. Prejudice has to be found. And there are standards for finding prejudice. So finding prejudice to another party from loss of the information, the court may order measures, no, this is really, really important, no greater than necessary to cure the prejudice. Sorry, hold on just a minute. You guys shimmy with the bushbirds for a second. So this rule measures no greater than necessary to cure the prejudice. So the court is not there just ready, willing, and able to put out the worst punishment immediately. You start with the simplest measure. Well, does someone else have access to this? Can you get this information some other way? Can it be forensically extracted? Something. Can someone sign an affidavit? I mean, are there, other possible remedies that are simple, that are not drastic, that are not severe, that could be done first? So that's the first, notice that's part one. This is what the statute tells the judge to think about first. 2, only upon finding that the party acted, this is important, with the intent to deprive. So that's two separate things, okay? So intent also has to be proven to deprive. So that means they purposefully did not want the jury to see this evidence, so they got rid of it. And this has to be proven, and it's Blake's burden to prove. Another party of the information's use in the litigation. So this two-prong thing, this is where we start. The judge has to consider that first. Then, these are what he does. If those two prongs are passed, both of them, not one of them, not part of them, presume that the lost information was unfavorable to the party. B, instruct the jury that it may or must, depending on the severity of it, presume the information was unfavorable to the party, or C, dismiss the action or enter a default judgment. So these are his three options if that two-prong standard is met. And like I said, they depend upon the severity of what the person has done and the willful intent. Now, I want to jump off of this for a quick second. This is what I was looking up and why I was late, because it took me a minute to find. So when did Blake ask for this preservation of evidence? Because they're going to make some really wild claims in here, going back to 2023, also going back to August of 2024. And what they offer as proof is just ridiculous. You don't get to just say anything, rewrite history, and say, well, that's what I meant. So you need to find a document with this specific type of language. In this one that wasn't filed until January, but we can presume that when someone files the CRD complaint, you would expect, there's a complaint being brought against you and probably a lawsuit. And then especially once a lawsuit is filed, those are understood, even if they don't put this language in there. But to refer to that 17-point list It didn't contain language like this. They were not under any legal obligation until the CRD complaint, the lawsuit, and here they specifically say take steps to preserve all of your communication relating to your statement, including without limitation all documents, ESI, metadata in your possession, custody, or control that relate to or reasonably calculated to lead to the discovery of evidence related to this matter in any way. This is the first time that I could find. I don't know if you guys have found something else. This was the first one I could find that she ever made this demand. And I mean, they could say the CRD because that's given, or the lawsuit, definitely. But there was never another document besides of those that gave this kind of instruction. So without that specific instruction back in, what did they say, November 2023 or May 2024, this just doesn't even fly. This is just Blake admitting she's got nothing, but asking the court to pretend that she does. I was thinking the emperor's new clothes. She's asking him to see that. Okay, then underneath this rule, and this was quite amazing, they've got very extensive footnotes that really go through and explain this law very, very thoroughly. And these are all things that the judge should be considering when he makes these decisions. Every judge. We're not going to read the whole thing because it's not even all here on this page. There's even more. But it does talk about, it gives even more, like even just the law itself had the two-pronged standard. But this goes even beyond that and starts to really, really explain. So it's not leaving the judges sitting there scratching their heads, wondering what it means, sitting there waiting and hoping that the Court of Appeals or the U.S. Supreme Court makes a ruling so they can understand it. It's not one of those laws. It's very clearly written of itself, and even more so here in its footnote. So it talks about the new rule applies only if the lost information should have been preserved in the anticipation or conduct of litigation and the party failed to take reasonable steps to preserve it. Many court decisions hold that potential litigants have a duty to preserve relevant information when litigation is reasonably foreseeable, not when it's a question, when you don't even know what litigation would be about, when that's not even clear, when it's a lot of people make a threat, I'm going to sue you, and never ever follow through with it, or even have a reasonable complaint that they could follow through with it. So a veiled threat is not the same thing at all. This rule does not apply when information is lost before a duty to preserve arises. And that's what we have in this situation. I just started using Signal myself. And there are different options about how long you want your messages to last before they auto delete. So if she's asking for stuff way after the fact and these things have auto deleted, we're not talking about people who sat there and said, oh, this message looks bad, let me just delete this real quick. We're talking about time passed and the app itself deleted through nobody pressed delete. It happened. So that's a very, very important consideration. When the app itself does it and it was not intentionally, manually done, you cannot claim intent. Let's see. The fact, this is the blue section, the fact that a party had an independent obligation to preserve information does not necessarily mean that it had such a duty with respect to the litigation. And the fact that the party failed to observe some other preservation obligation does not itself prove that its efforts to preserve were not reasonable with respect to a particular case. So when you start reading this law, you realize this isn't some absolute, like, oh, you don't have it, bam, you're sanctioned. Not at all. This rule only applies if the information was lost because the party failed to take reasonable steps to preserve the information. And then here, due to the ever-increasing volume of electronically stored information and the multitude of devices that generate such information, perfection in preserving all relevant electronically stored information is often impossible. I remember a case, it was in fact the Murdoch case. A phone had not been properly sealed, so it was still trying to read information around it because our phones, they're busy doing stuff even when they're just sitting there turned off next to us. Well, what can happen is information will start to overwrite. And that's not you doing anything. That's just the nature of the electronic device. So not everything disappearing from a phone is sinister. So the initial focus is whether the information can be restored or replaced through additional discovery. And it's interesting that in her document, she mentions that Skyline has these. So what's the fuss about? If you have a remedy, that's what you're supposed to use. You're not supposed to come crying and saying, they did this, punish them. You use that remedy first. Okay, let's see. What else is important on here? I don't want to go through all of this too much. I love this boring nerd law stuff, but I don't want to bore you guys to death. Okay, this applies only if information should have been preserved in the anticipation or conduct of litigation, a party failed to take reasonable steps to preserve the information was lost as a result, and the information could not be restored or replaced by additional discovery. An evaluation of prejudice from the loss of information necessarily includes an evaluation of the information's importance in the litigation. That's what I was talking about. Some things have to be proven, and this is one of them. Thank you, LJ. She says, also, wouldn't they have to prove they maliciously chose not to change the auto delete feature? Yes, they would. Or save the voice message. People delete all the time. They do. Some people don't like a bunch of stuff cluttering up their phone and delete everything. Some people save everything, and some people are somewhere in between. It depends on how much space you have on your phone or your personality. Some people don't like clutter anywhere, even in their devices. So that's why this is in the rules, that there has to be an evaluation about this first. You don't just immediately assume that it was done maliciously or purposefully. Then we have a case cited here that rejected giving this adverse inference instruction to the jury because severe measures to address this are only brought with the finding that the party that lost the information acted with the intent to deprive another party of the information's use in the litigation. So the judge, this is not, and I imagine he's not happy finding this. His docket, as we know, is overflowing as it is. He's already said he's not going to rule on the motion for judgment on the pleadings until he rules on the motion for summary judgment, letting us know he just doesn't have time right now. So I'm sure that seeing this does not please him, because if he has to investigate things like intent and prejudice, he might have to call these people to have a hearing before him and hear this out. He's going to need to ask questions of the Wayfarer parties. He may do it in a formal hearing. He may do it in camera. We don't know, but to have to find these facts first to make a ruling on this is not a simple thing. So I imagine he is not pleased. And you know what I wish for? I wish for a sua sponte, which means you don't even have to ask the judge just does it on his own. I wish that he would come forward sua sponte and say, knock it off already. You filed how many motions for sanctions now? Knock it off. This is frivolous, and this is wasteful of the court's time. I don't know if Wayfarer wants to file something to say that, because they always get yelled at by this judge, and they might be afraid it will just end up making him more angry. But this This is frivolous and it's a waste of the court's time. And someone needs to tell her, stop it. Put your crayons away, put your glitter glue away, and stop it. We know you're sitting around unemployed, but stop it. Got 2 nannies taking care of your kids. You got all the time in the world to use your glitter glue, but the court doesn't. Yes, he did, Monica. I'm glad you brought this up because I forgot to add it to my to my slides, and I thought of it this morning. Monica says, I feel like on August 29th, Lyman already took a side on the issue with the signal chats in reply to a motion to compel Jed Wallace. No one can produce documents that don't exist, and this is correct. So they should have noticed that he's already kind of taken a stand. He hasn't, and this should let them know how likely he is to rule on this. But this is just such a desperate motion. Now, for looking at, this is going to sum up the law because I didn't go through all of it. But if you are a law nerd like me and you love this stuff and can't get enough of this stuff, if you go to that law 37E and then you scroll down underneath the law, you're going to find an abundance of footnotes. And that's where I got what was on those screens. And you can read every word of it. I think that stuff like that's interesting, but I don't want to read every word of it to you guys because I know not all of you will. So in addition, this is just some extra information that I added. We don't know which state law he's going to apply to the case. So 37E is federal rules. But if he's applying state rulings on it, California law allows adverse inference in cases of spoliation if the evidence was destroyed intentionally. So that's the requirement there. New York requires a showing of bad faith before an adverse inference can be drawn. So again, these are things like intent and bad faith. That's not something the judge can just sit down and easily rule on. That takes time and possibly investigation, possibly a hearing, even if it's just an in-camera one. Okay, then this kind of sums up the legal elements, the key legal elements, that there has to be existence of a duty to preserve evidence, failure to produce the evidence when requested, the evidence must be relevant to the case, and absence of the evidence must lead to a reasonable inference against the party. Okay. And then I have a couple of definitions. So spoliation is the intentional destruction or alteration of evidence. So it's not always destroying it. We're going to go over a few cases that actually altered some emails, and that would be spoliation too. So it's not just that it's not there. Oh, I feel like I'm going to sneeze. Sorry. All right. Presumption is an assumption made in the absence of evidence to the contrary. And presumptions can be rebutted with evidence, while adverse inferences are drawn specifically from the absence of evidence. Now let's get into this word slop from Ezra, this 30 pages of word slop. Oh, here's where the Bushbirds come in. So here's what I wrote. Hey, Ezra, go watch the Bushbirds reading the criticism about Blake long before she fell out with any member of Wayfarer. You'll see that it started before she even started filming, while Wayfarer, as we've seen in messages, was doing a happy dance that she agreed to do the film. Bless their hearts. Then watch the part where people first saw her ridiculous appearance in the film. Again, while Wayfarer was still thrilled that she was filming. Learn all about the organic publicity. And if you guys haven't watched that, Bushbirds go through comments, and it's really funny. But they dug up some comments from years ago where people were talking about Blake. And the thing that they always forget to focus on is that during a lot of this stuff, the majority of this stuff, when they're being accused of these things, they were putting this film out. Arguably, Wayfarer's biggest film up to that point. Why would they want to do things and put things out there that was going to make their film look bad? The answer is they wouldn't. They wouldn't. That would be shooting themselves in the foot. And whether they liked Blake or not, she was the biggest name star in the film. And to have to put stuff out there to make her look bad makes their film look bad. They would not have wanted to do that. And they were upset. We see them in text messages. They were upset that it was happening because of those reasons. So that's what makes this paragraph from Ezra so stupid. But she says their defense from the outset has been that they never moved beyond the scenario planning stage. So she's talking about this campaign. They love to bring up this leave no footprints and this bury. They love to use this word bury. And Wayfarer has rightly said all of those conversations were scenario planning. These things happened before they even hired Jed Wallace. These things happened when Melissa Nathan first came on the scene, and they were just talking about what they were going to do, and it all was not offensive, it was defensive. In the conversations, all of that is very, very clear. If she does this, what are we going to do? Another thing, that if you're smart enough to read those text messages, you come to the conclusion that they're not talking about an S harassment claim. That's not what they think they're about to defend. They think they're defending about all of the trouble behind the scenes, fighting over who is going to edit, and all of those things, the firing of people, Blake's fits, all of the problems during filming, the fighting. That's what they thought they were defending. And you can see it. If you're a discerning person, you can see it in their actual text messages. So this whole planning stage was about that. If Blake starts saying these things, this is what we'll say. And she's throwing it in their face like, oh, they keep saying this. They keep saying this. Well, how about, what else are they going to say if this is the truth? Of course they keep saying it. What else are they going to say? Are they going to make stuff up like you do, Ezra? Allegedly, in my opinion, don't subpoena me again, Ezra, with an S. And then she talks about the mocking. And I'm sure a lot of that is us because, yeah, we mock. We mock. It's stupid. Is it untraceable or does it not exist? Because nothing is really untraceable in today's world. But then she says that they get mocked for this word, but she's like, we didn't say it. Melissa said it. It was first used by defendant Nathan, but we get mocked for it. It's so childish. And then they talk about routinely taunting Blake that she will not be able to prove it. She won't be able to prove it because it didn't happen. Insisting that the sudden onslaught of negative publicity against her beginning in August 2024, it didn't begin in August 2024. Go look at the Bushbirds. Was organic, coinciding perfectly with their plans by sheer luck. It didn't start in August. Go look at Reddit. I don't normally like Reddit, but I loved the Colleen Hoover subreddit when I first saw it. Like after we saw posts of it in the complaint. I think it was in the timeline. And so I went there back then, and it is hilarious because you see the people who loved the book and they're talking about the book for a really long time because the book just kept coming back to like the top of the charts over and over again for a period of years. People loved this book for some reason. And so they had dreamt about who they wanted to see play the character or who they imagined the character to be. And the very first mention of Blake Lively starts the whole thing. This is long before 2024, long before that. There were even people who liked her, but they're like, she's not it. She's not my Lily. And then they named these other actresses, and I looked all of them up, and I'm like, yeah, I can see why they were disappointed in Blake. Then when she showed up wearing 2 pairs of pants and a t-shirt tied over like some hideous jumpsuit wearing Ryan's socks and it looked like Ryan's dress shoes. I'm like, "What is she wearing? Did she time travel to the '70s to get that jumpsuit?" And I know I'm calling it a jumpsuit, but and that's fun. I'm doing that just to be funny because that's what it looked like. It didn't look like anything anybody currently wears. It looked like something from long ago when they called those things jumpsuits, and then tied a T-shirt over it. It was crazy, and the internet went wild because what the heck was she doing? Yes, the frizzy hair, which now we saw confirmed that it is a wig because there were pictures of the dressing room and we saw her wig hanging on the back of a chair or something. So if you haven't looked into that, you can't change dates on Reddit. It either happened back in 2022 or it didn't. There's no way to change those dates. But this just it didn't appear by sheer luck to coincide with anything. It was already there. Jess saying says, it's fashion, Cassidy. You're just not as on trend as Blakey Blake. Yeah, like that rooftop scene. We're supposed to believe that her showing up in Carhartts and that hideous shirt is going to make this wealthy neurosurgeon, this hot, wealthy neurosurgeon who gets any girl he wants. He says no girl's ever turned him down. Like it's never not worked on anyone. But he sees this frump city on a rooftop and is just wildly in love. Just can't forget about her. Come on. It was so unbelievable. The whole thing was just and it was organic. It was organic because you look at it. I'm no fashionista. Okay? I've been known to buy some pants at Costco. I'm not lying. But even I wouldn't wear that stuff. You need some conditioner. Frump City. Frump City. Yes. It was Frump City. It was her clothes were just absolute frumpy. And I'm not body shaming her at all. I'm talking about the actual clothes. Cuz as much as we don't like her, we have to admit, for someone who just had a fourth child a couple of months before she started filming, there's nothing to shame about her body. For sure. So I'm not talking about her, I'm talking about her style of clothes. And they got you go through and you see these organic TikTokers and they were literally going through their closets and putting on like multiple pairs of pants and ridiculous shirts and stacking the beanies. These are legitimate TikTok accounts that are still alive to this day. They were not bots. They were not hired by Melissa Nathan or Jed Wallace. These were young kids who saw something ridiculous and made a joke of it. There's nothing more organic than that. It coincided with the movie coming out, with people seeing her at the premiere, marketing this movie in a ridiculous manner, pretending it's a rom-com when it's a very serious topic. So this wasn't by sheer luck. This wasn't coincidental. She brought it on herself. And in August 2024, when this movie was premiering, the last thing any member of Wayfarer wanted was criticism that was going to affect their movie. Plain and simple. And then they're always, I always talk about this, the difference between Ezra and Michael Gottlieb's writing and Wayfarer's writing, like Kevin, Ellen, when they write, it's beautiful. It's like a work of art. And they put just enough sarcastic sass that it's just so enjoyable to read. But these people are just nasty. You can't tell I can't tell the difference between Ezra and Michael. I really can't. They write exactly the same. But it's just like all these like nasty little accusations that they have no proof of, but they keep saying it anyway because they know it's going to get picked up in mainstream media. So they get accused of hiding the ball at every turn in the discovery process. Failing, hey, they gave you 5 years worth of video, Ezra. 5.5 years worth of video. That's a joke if you guys are thinking I'm serious. If you didn't know about that, the math that they did about the gigabytes of filming they got, the math that they did came up to, they said how many hours it was, which translated to 5.5 years if you run it 24 hours a day, 7 days a week. Okay. Despite defendants' clumsy efforts to cover their tracks, there is substantial evidence that the retaliatory campaign was, in fact, implemented as planned. Please enlighten us with this fabulous evidence, because if you had it, you wouldn't be filing this motion. 2. Defendants flouted this court's orders and destroyed. That is a wild accusation to just say they destroyed it, and or failed to preserve or produce additional material and highly relevant evidence. Ezra, you thought my bank account and credit card information, my geolocations, my subscriber information, my physical address, what else did you ask me for in that Costco bulk subpoena? You thought that stuff was highly relevant. Did you want to buy my Costco pants? Is that why you wanted to see my credit card information? I mean, you fought for my information, claimed it was highly relevant. We don't believe you anymore when you say something is highly relevant. You thought Perez Hilton's was highly relevant. What'd you get from that? What'd you get from Megyn Kelly? Big fat zero, because it doesn't exist. I never communicated. I never had communication with any member of the Wayfarer party. Not even by extension, but you claimed in a legal document that I did. You said my name was on a list somewhere that I had communicated with them. You're just a liar. Plain and simple. They were not required to preserve anything until they were notified of the complaint and the lawsuit. So during the time that Blake and Ryan were busy running to the New York Times, hiring Manat to use Van Zandt to file a sham lawsuit to get a sham subpoena to scrape the contents of Jennifer Abel's phone, including things that they're now in possible criminal trouble for doing, they chose to keep these underhanded moves below the radar. So how would Wayfarer know that they needed to preserve anything? A simple solution to this would have been if when you filed your sham Van Zandt lawsuit, you had let these people know that you were filing it, as you should have. And then you could have put that little wording we saw a little bit ago to instruct them to preserve it, but you didn't. You did all this underhanded, most likely illegal stuff under the radar, and now you're mad that they weren't preserving it while you were stealing it. Allegedly, in my opinion. Don't subpoena me again. I know you want my Costco pants, Ezra, but they won't fit you. So, I also have in my notes here because we're here. In my last video, when I went back and was listening to it, and I saw that I said a wrong name when I was, because it was a really heated moment when I was yelling about Judge Lyman wanting an in-camera review of text messages, and I said Jennifer Abel and her father. I don't know what Jennifer Abel's father is. I don't know if he's an attorney, but I meant Katie Case. We've talked about Katie Case so many times, and those text messages between her and her father, who's an attorney, and that they talked about the family dog. And that's who I was thinking of, but because I was like really mad and worked up, I said Jennifer Abel's name. So I don't know if you guys caught that, but the thing about YouTube, I can't go back and change that. The only editing you can do on YouTube is deleting. So, and I don't know how I can like take the name out and not take out the whole information. I'll figure something. But if you guys saw that, it wasn't Jennifer Abel and her father. I don't even know if her father's an attorney, but it was Katie Case. And if you follow me, you know we've talked about that situation before. But I was so mad because here was this possible criminal action that Stephanie Jones and her security team had taken against Jennifer Abel, and they asked the judge to have an in-camera hearing on possible criminal behavior. And I can't imagine any judge who would refuse, but this judge did refuse. And then when he's asked about these text messages between Katie Case and her father, I almost said Jennifer Abel again. Katie Case and her father, he's like, oh, I'm all in. I must read these messages. So ridiculous. But thank you, Mr. Lord. Thank you so very much. Ezra is still a lying space on Java and couldn't ever fit into anyone's anything. But I'll try to clip that out later if I can sort out a reasonable way to do it. But anyway, so then she gets into more accusations. Brian Friedman was a participant. They really hate Brian Friedman on at least some signal communications with the defendants by August 2024, and yet apparently did nothing to ensure these key communications were preserved. Why would he have preserved them when he was hired at that point? We don't know what he was hired to do. We know that it was a troublesome, I want to say it was a troublesome production. That's the word I'm looking for. We also know that a lot of companies have attorneys, even if there's not litigation or even the threat of litigation. They need to consult them for different things. We also know that they may have been wanting to take some kind of action. So making this big assumption that Brian Friedman was hired for S harassment is ridiculous. Why would he need to ensure communications were preserved if there was no active litigation telling them that he had to do this, or no active direction by an attorney telling them that they have to do this? You think attorneys just walk around preserving all communication when they don't need to? I mean, how big of a server would they need to store all that stuff? They contemplated litigation as early as August 2024, but what kind of litigation? Like I said, they may have been pursuing it. They had no idea that she was going to file this lawsuit. And she didn't until the very end of December, months later, clearly aware of the possibility of legal action by November 23, yet took no steps whatsoever to preserve their signal or voice memo communications until December 20, 2024. Lady, were they even using Signal in 2023? Is there any evidence to suggest that they were? Isn't that something Jed Wallace suggested once he was brought on? Nowhere near November 2023. These arguments make no sense. They always have no basis and a lot of times no truth to them. And then she goes into this. They produced no documents and provided minimal testimony about the work they claim the Wallace defendants actually performed. Maybe because he didn't end up needing to do much, because your girl is annoying and brought all this on herself. And she's actually, they just keep describing it with one word, monitoring. Maybe because that's all he had to do. They can't accept the truth. And that's the thing. When people themselves lie all the time, they think everybody else is lying because they know that they are. So they cannot accept that these people might just be telling the truth, and that the reason they keep repeating the same thing, and that the reason she can't find anything is because it doesn't exist. It's crazy. And then she jumps straight to severe sanctions, in spite of the fact that that's not what the law says. Ezra's a California attorney. She knows what her state says about this, but still comes right in here asking for the severest sanctions available. And that is what she asked for later. She asked for the most severe. She jumps straight to it, although the law clearly shows that's not what you do. I'm going to have to hurry this up. I can't believe I've already been on here for an hour. So here's what Blake seeks: an adverse inference that defendants intentionally deleted and failed to preserve relevant evidence when they had an obligation to do so, and that destroyed evidence would have further shown defendants' execution of the digital campaign. 2. Preclusion sanctions to prevent defendants from arguing. This is what she really wants more than anything, and this is why I put it in my letter. From arguing that they did not execute their digital campaign as they openly planned to do, or that the Wallace defendants did not actually engage in the digital campaign services they were hired and paid to perform, given the destruction, you have to prove its destruction, of documentary evidence that would otherwise show what the Wallace defendants actually did. You have no proof of any of this. And 3, monetary sanctions, at least in the amount of, and the funniest word on the whole paper, Miss Lively's reasonable attorney's fees and costs. $2,000 an hour plus costs are reasonable, folks. Reasonable. So this is what she wants, just like I said in the letter. She wants the judge to tell the jury to just believe her that this happened with absolutely zero evidence that it did, and then don't give them a chance to say that it didn't. It is so outrageous. I can't even believe that someone has the gumption to put this on a piece of paper and file it in a court of law. What privilege does this woman think she has that she can say, believe me with zero evidence, and don't even let the other side defend themselves? It's the craziest thing that I've heard in this crazy case. I have never heard of this kind of thing, ever. And then she talks about this return to production letter. This 17-point demand is getting almost as powerful as the buy one, get 106 free Costco bulk subpoena that I got. It seems like it can be used anytime, anywhere, any way that they want it to. So now it should have signaled Wayfarer to start preserving evidence, things that hadn't even happened yet, for a lawsuit that wouldn't be filed for over a year, and that they had no idea what the claims would be, that they should have been able to see into the future on November 9th, 2023, that Blake was going to take control of the editing, the music, control Isabella's nudity writer, illegally share the film with friends, steal the film and fly it to the book bonanza and share it in its entirety before Sony has even passed on or agreed to it, agreed to the cut. They certainly told her not to do this, to a group of fans. They didn't know she was going to tell people that her husband wrote for the movie, even though a person is supposed to be credited, hired, cleared to work on a movie. She's out there telling interviewers, the media, that her husband wrote on it. You can't have that. She's out there telling people that Taylor Swift helped with the casting and was there for every decision, every step of the whole movie. And then, with the help of Powder Bear, her PR agent, that she would start defaming Justin and the Wayfarer parties, and that they would need to hire a PR crisis team to monitor Blake's releases of information, even though it has nothing to do with this 17-point list. And this 17-point list, yeah, I just happened to glance, like Victoria says, they had every right to lawyer up and protect themselves as soon as they saw that. That's what that should have triggered them to do, not to think, oh, she's going to sue us, so let me start preserving everything. There was nothing in that word salad, word slop mess list of demands that she used to take over the movie that told them to preserve anything. And then we get to this whole section, and this is just ridiculous. All these redactions, every time they've done this, I've always said, this is to make us think there's something really, really big there. And we get all excited, and eventually it gets unsealed, and we read it, and every time it's a big ol' nothing. So I'm assuming, when I see this, I don't even try to read around it, because I'm like, this is going to be nothing. This is all here to make us think they've got this mountain of evidence. But in the end, we know it's not going to be. So let's just skip right past it. And then they go through this rehash of the same old tired accusations that we've been reading since the New York Times article. These are normal public relations moves. There's nothing illegal about this stuff. There's nothing abnormal about this stuff. This is flat out PR. A million PR specialists have talked about it, and they won't stop repeating it over and over and over and over and over again. Thank you so much, Victoria. But they put an evil spin on it and make it sound much more sinister than it ever was. She just continues droning on, same accusation here on page 7. The only interesting bit is the part I highlighted. She puts in italics, which normally you only do that if you're quoting from someone. So I don't know if she's trying to make it look like this is a quote, but it's not a quote. It's just her interpretation of something. The decision to conduct business with no paper trail, including via the use of ephemeral messaging capabilities for digital services, was not an accident, but rather the plan all along. Or maybe it's quoting from one of her something she's posted before. But it's not something, because she starts off with a quote from Katie Case, the without fingerprints, and then she puts the next bit in italics too. But that did not come from Katie Case. So it just, I felt like she was being tricky with that and trying to see if people would assume that that was also a quote from her to make it look worse. Maybe because since they didn't have to implement the plan beyond monitoring, they just didn't bother with those protocols, and they just chatted in regular messages. And what you think exists doesn't, because we have them chatting in plenty of other message mediums. So to me, that kind of signals that they didn't keep on Signal that long or use it that extensively. Maybe they just kind of drifted into the others because they were communicating about all of this stuff on regular message chats. So what they think and are imagining must exist on Signal might not even exist, except for in their heads. Okay, more redactions. I don't waste my time on this at all because I think it's just put there to look like they got a lot of juicy evidence when they don't. And that's probably what we'll find when it gets unsealed. But again, we have that 17-point demand claiming that that was the start of needing to preserve evidence. It's not. And I hope Judge Lyman sees that. You never know with him. And let's see. What else did I want to say about this? I'm trying to cut out some of my notes because it's just getting a little bit too long here. And I really had a lot more to cover. I might stop this and do a second one about the cases, because I have some cases that I wanted to compare with past rulings. So I think that's what I'm going to do. I'm going to finish this document. I'm going to have a little break, and then I'm going to come back and go over the rest of it. Because if I continue like this, we're going to go into 3 hours, and that would just be ridiculous. But there was just so much information that I wanted to share with you guys from this, to show you the rules, and then the other part is the case law, what other judges have decided, but specifically, and I wish I had noticed, because one of the things I focused on in the last episode was what Judge Lyman should have considered when he ruled on the motion, Stephanie Jones' motion to dismiss Jennifer Abel's claims. Because when I found in there that he blatantly disregarded what the Supreme Court ruled and said, well, here in the Southern District of New York, we see it this way, that was so shocking to me. And the point of that, as I put up a post later, is that not to say that there weren't other reasons that he could have focused on to dismiss those claims, but the fact of what he used to dismiss those claims was a Southern District of New York ruling from the lowest court instead of the U.S. Supreme Court ruling and the Court of Appeals ruling and the statutes that are set up that you're supposed to follow with these things. So that just really got me thinking, and I wish I had noticed that earlier, because I wish I'd been doing this all along. So what I did, and I'd always said that the case law that Ezra and Michael Gottlieb used, especially Michael, that they used was always so ridiculous. It never really went well with their claims. So I focused on what her rulings were, and she used a lot of Southern District lower court rulings too. So what I did, what I'm going to go into the second one is, how do they add up with binding authority? Because that's what Judge Lyman has to consider, not these little Southern District of New York cases. And one of them is his. So I want to, like, from here on out at least, but I'd like to go back at some point too, if there's ever a free moment in this case. But I want to see how often this man rules on his own instead of on binding authority. So what's a good place to end? I think a good place to end this one is, well, here she says they cannot be replaced. In the earlier bit, she said Skyline had them. So I don't understand, unless she thinks there's some that exist that even Skyline didn't have. But it's just so silly. But here's what she demands, or respectfully seeks. This is what she wants the judge to say to the jury. Defendants intentionally deleted. You have to prove intent, and you have to prove that they deleted and failed to preserve relevant evidence for this litigation. If you've never seen it, how do you know it's relevant? Defendants anticipated litigation with Miss Lively by at least August 2024. Prove that. You didn't prove that, but nonetheless elected to use methods of communication that automatically delete, such as Signal, and as to the Wallace defendants, voice memos to discuss the execution of the digital campaign against Miss Lively. And the defendants failed to take affirmative steps to preserve such communications prior to December 2024, you may presume from defendants' failure to preserve these Signal communications and voice memos that defendants did, in fact, execute the plan that TAG recommended and for which the Wayfarer parties retained the Wallace defendants, and the defendants intentionally failed to preserve their communications in order to hide this fact. Can you imagine? This is basically the judge standing up, saying to the jury, we don't need you. We don't need this trial. Just say guilty now. Believe that this stuff happened with absolutely no evidence. We're not going to show you any evidence. All we need is Blake's word, and the other guys don't get to talk. I mean, if you direct the jury to follow this, what's the point of a trial? These people don't get a chance to defend themselves, and you don't even need to see any evidence to believe Blake. What's the point of a trial? It's like just sign here, say guilty, and you're dismissed. It's insanity. And then she asks for sanctions, the monetary sanctions. Are you not paying your attorneys? Is that why they keep begging the court for money? What's going on here? All right. I don't want to forget anything else before I close this one out. And then I'm going to take a little break and come back in a bit. But I'll give you guys a break from me because it's been it's been an hour and 20 minutes. So I'm just trying to sort out what I wanted to say to close this off so that this situation is closed off. I think we'll just stop here with her asking this of the court with all of her gall. Yeah, this will be a good place to start the next one. So we will start here. All right, guys. Thank you so much for joining me. And yeah, I really did not estimate right about how long this would take. But yeah, that's what we're going to talk about when we come back, is what cases as recited as proof to support what she's asking the judge to do, and what the binding authority is, because that's really important. All right, guys, have a great rest of the day. If you can't come back and join later, thanks for joining now, and I will see you back here really soon.